Many YouTube videos are providing incorrect information that if you are on a skilled worker visa and you will apply for the extension after 2 years, you will get the ILR after 10 years. So in this video, I thought to clarify what the gov.uk says. So this is the paper which was published, policy paper, and this is published on gov.uk on 12th May 2025. So these are the two documents which we are talking about. The first document is Restoring Control over Immigration System, May 2025. In my other videos, I have discussed this whole document already by line. I have discussed that. So in this video, I will be discussing that what actually the rule says for the transition period. So for example, if you are on a skilled worker visa and you will apply for the extension, what this document says. So without wasting time, let's discuss three most important thing in this video. Number one, legal implications of 10-year route to indefinite leave to remain. Number two, we will discuss practical challenges for employers and sponsored workers. Number three, we will discuss uncertainty around implementation. No transition provisions confirmed. At present, sponsored workers on the skilled worker route can qualify for ILR after 5 continuous years of lawful residence. ILR offer long-term stability, exemption from sponsorship obligations, and eligibility for British citizenship. Extending the qualifying period to 10 years would require migrants to remain on temporary visas for twice as long, potentially triggering multiple visa renewals. Each renewal brings additional costs, including visa application fees, immigration skill charge, and legal administrative expenses. Furthermore, employers must continue to meet sponsorship duties and bear the risk of losing employees midway through the extended pathway. Critically, the white paper provides no detail on transitional arrangement. It remains unclear whether the new 10-year rule will apply only to future entrants or whether it will be imposed on individuals already on a 5-year route to settlement. The absence of guidance on this point introduces a high level of legal uncertainty for migrants and their sponsoring employers. Now let's discuss the practical challenges for employers and sponsored workers. For employers, the change could complicate workforce planning and increase the cost of administrative burden of sponsoring international staff. Currently, it's based on 5 years. The Home Secretary announced an increase of 32% of immigration skill charge in her speech, which is another cost. From the perspective of international professionals, the appeal of relocating to the UK may diminish. And what will happen? People will start thinking of going somewhere else. 10-year period of qualifying for the ILR is way too much, and that will be impossible if we consider on a real basis. And without the transitional protections that, for example, if you're on a skilled worker visa and you don't know that whether you will get within 5 years or 10 years, no one will come to UK. This could be particularly disruptive in sectors such as financial services, life sciences, technology, and engineering, where international mobility is high and long-term planning is critical to business continuity. But these white paper don't say anything. So the YouTube videos which are saying that if you are on a skilled worker visa, you will get ILR in 10 years, even if you are already in the UK, is baseless because we don't know the reality yet because it's not been published yet. Now let's discuss the last part, uncertainty around implementation, that no transitional provisions confirmed. The government has confirmed that further consultation will take place before any changes to ILR policy are implemented. However, the white paper does not specify when the new 10-year rule will come into effect. whether the change will apply retrospectively. What if any transitional arrangement will be made for those already in the UK on 5-year pathway to settlement? Nothing is cleared in the white paper. This lack of detail creates considerably difficult for legal and HR advising on immigration timeline and long-term relocation strategies. It also increases the risk of misunderstanding or miscommunication with sponsored employees, many of whom may be relying on the existing 5-year settlement framework. So, still, we are waiting for the clarity that what the white papers actually means, because the guideline is not clear yet. So assuming stuff is not good, and based on the assumptions or watching YouTube videos which are not providing any evidence is not right. The best is go on gov.uk and you have these documents. These documents you can download them and you can read them yourself. On my channel I have created this video in which I have showed that what these papers actually say. If you have any question, you can send me an email at dr_khan consultant.com.